practicing, the IP in the IP industry as a patent attorney from more than 25 years. But when I met him for the very first time, the views that he had about the industry, about this profession of IP attorney was so different than what I have heard from, by talking to people in Europe, in US, or all the different, the places. And that was very, I don't know, I should say amusing or surprising, because his thoughts were very different. And it was more of how this industry, the vision of how this industry should run or should be run, and sticking to what is right rather than just practicing what everybody is doing. So having said that, rather than talking about his experience in the top law firms, in the corporations, I would pass on to Eric and directly, request him to share that, what he feels about what should be done in this industry at this point of time. So over to you, Eric.
Thanks, Deepak. Thanks for that introduction. Again, my name is Eric Halber. I'm Senior Vice President of IP Solutions at GreyB Services. And my experience has been over the past 20-25 years. Currently, I provide IP solutions for clients in the US and in Europe with respect to various IP problems. I began practicing commercial litigation in 1991. In 1997, I moved to IP litigation and prosecution and spent many years in private practice. And then I switched to in-house counsel, and I was in-house counsel for several companies, a couple large companies and then a small company. And then in 2009, I founded my own IP consulting practice, where we focused mostly on monetization and monetizing patents and portfolios for small and mid-sized companies. Now, what I'm going to share with you today in this webinar is a number of issues which all end up being focused on inter-parties review, as it's currently being done at the Patent Office, and the high invalidation rates coming out of IPR trials. And I'm going to bring in a number of different issues, including attorney ethics, patent valuation, things like that, to try to give some understanding on how we can change what's going on with respect to high invalidation rates coming out of the IPR process. Over the past 25 years, I've represented many clients, and I've been a client myself. So I have a firm grounding on the issues surrounding attorney-client relationships. And again, we'll be talking about high IPR, that's inter-parties review rates, and how these high invalidation rates represent a substantive change in IP law. We'll also address why IP attorneys need to educate their clients on these high IPR invalidation rates, and a few ways to address this problem. Now, I came across the IPR invalidation rate issue several months ago. A few years ago, I was representing a client in an enforcement action against a very large and well-known company. We had filed suit at the district court, and as that suit progressed, we found ourselves winning every issue, including receiving a 100% favorable claim construction. Now, shortly after that claim construction, the defendant in the case filed an IPR request with the PTO. That request was eventually accepted by the PTO, and a trial proceeded. That's when I had to dig in to the IPR statistics, and that's where I found that the invalidation rates were so high that most of the claims being brought before the IPR boards were being invalidated. Let's take a poll at the very beginning for the attendees. I want to ask you this question, and I'm going to open the poll right now. Let's see, here we go. And you get a chance to answer yes or no. Do you feel that most U.S. patents are valid? I mean, after all, under the U.S. statutes, U.S. issued patents are presumed valid. So, in your experience over time, do you feel that most U.S. patents are valid? And As you answer the question, I'll give the results as we go along. Also, one housekeeping bit of information. You may have questions as we go along. I'm going to reserve some time at the end of this webinar to take a look at the questions and answer as many as I can during the time we have. Attorney-client relationships come in many different forms. There's the formal relationship, which is governed by, say, a retainer agreement or standing instructions from a client on what to do. There's the informal relationship, knowing a client inside out through correspondence, discussions, phone calls, emails. There's also an educational aspect to attorney-clients, and that usually comes about when there's a notification of a substantive change in the legal landscape. And that can happen with firm newsletters that usually focus on litigation results, new cases coming out of the Federal Circuit, new legislation, and more recently there's a lot of talk about the inter-parties review process that was established by the American Inventors Act, which started in 2012. In this webinar, we're going to look at what is the true impact of high invalidation rates coming out of the inter-parties review trials. And then the second issue will be, are IP attorneys required under the rules of ethics to educate their clients on the issue of high IPR invalidation rates? Two separate issues, but coming together here in this webinar because I think it's such a clear, substantive change in consider patent valuation or the substantive value of patents that it needs to be discussed in terms of both what is happening at IPR trials and what attorneys should be discussing with their clients. Now, a patent portfolio represents value. And recently, I had a discussion with a client. It's a very large company. They have a large and very strong patent portfolio. And he was saying to me that if someone else wanted to create a similar portfolio, they would have to spend a few $100 million, and it would take tens of years. Most companies may not have that money, may not have the time. For example, Google didn't have the time. They were willing to spend $4 billion to acquire the Motorola patents. Now, today, Google would not have had to pay $4 billion for that Motorola patent portfolio. Why? Because, as we'll see later on in one of the other slides, which I'll show you, the cost per patent has gone down significantly since the IPR trial proceedings have been available to challengers of patents. Now, an effective attorney-client relationship helps maximize patent value in a number of ways. One effective way to increase value involves education by the attorney. And what I want to talk about today is an overlooked issue with respect to IPR trial statistics, with respect to the high invalidation rates. What can you do about it? Let's first talk about what the IPR process is all about. And I'll give you just a summary, brief summary. The IPR trial process is an option that gives a challenger the ability to challenge the validity of patent claims. And this often comes up when a company is sued in the district court and they find themselves to be a defendant in a patent action. They have the option under the IPR process to stay the district court litigation and take the patent claims and challenge them at the PTO in an IPR proceeding. That can be very beneficial, as we'll talk about later on, because the IPR process is very beneficial to challengers. The basis for a challenge in an IPR proceeding is patents or printed publications only, and involves only sections 102 and sections 103 of the patent statutes. The prior art either anticipates or the claims are obvious in view of the prior art asserted. What's the standard to initiate an IPR trial? And I'm talking about here the standard that the PTO uses to accept a case for trial, not to give the trial and provide an ultimate judgment, but initially just to accept the request for trial. The standard is a reasonable likelihood that the petitioner would prevail with respect to at least one of the claims challenged. So what's that telling a patent owner, if the case is an IPR trial, is that already the patent office believes that one or more of the challenge claims are invalid. That's very different than what you would see at the district court, where you have to go all the way through trial and the defendant has to prove invalidity. The burden of proof in an IPR trial is preponderance of the evidence. We call that 51%. Preponderance of the evidence standard is very different than the standard seen at the district court, which is clear and convincing evidence. So it's a much lower standard with an IPR trial. IPR favors the challenger. In addition to the lower standard, the IPR trial board will use the broadest reasonable interpretation standard for interpreting the claims. And what that means is it's usually much easier to invalidate broad claims in an IPR given the prior art asserted. It's a much lower burden for the challenger compared to a civil trial. And the key aspect here is the presumption of validity does not apply. In a civil proceeding, U.S. issued patents are presumed valid. That presumption of validity does not apply in an IPR trial. So what's the result of all these benefits to the challenger? Well, the IPR process started in 2012. We're going to be looking at statistics as of July 31, 2016. In that 4-year period or so, 3,410 IPR petitions were filed. Of that number, 1,738 trials were initiated. And of the 1,738, 1,086 reached a final decision. Now this is key. This next slide is key. Of that 1,086, 764 of the trials, all the claims of the challenge patent were found invalid. That's about a 70% invalidity rate. I'm going to stop here and pause because I want that to sink in. In 761 of those 1,086 cases, the PTO boards found that every claim challenged was invalid. Also, in 164 of those cases, some of the claims were found invalid. That's 15%. So together, 85% of the challenged claims were either found invalid or some of them were found invalid. Only 15% survived, where all their claims were found valid. Now, why are the IPR statistics relevant to inventive entities? Again, we talked about the broadest reasonable interpretation standard. It's much easier to invalidate patents in an IPR than with respect to a district court trial. I was looking at recent statistics. There was a Law 360 study between 2008 and 2014, and in that study, looking at district court cases, they found that between 15 and 20% of the patents were found invalid. That's much lower than what's happening in IPR proceedings. Again, you've got a lower burden, preponderance of the evidence standard, compared to the clear and convincing standard used at the district court. And I want to harp on this. The presumption of validity does not apply in the IPR proceeding. Now, back in 2012, after 2 years of statistics, Rob Stern and Gene Quinn, two very prominent patent attorneys, concluded that no commercially viable patent seems safe in view of the IPR process. Pretty strong statement, and I happen to agree. I think the statistics are so harmful to patent owners that they represent a clear challenge to the validity of all issued patents out there. These IPR invalidation rates seem to be a game changer. If we take a look at the cost of patents sold between 2012 and 2014, a recent study suggests that in 2012 you had 7,000 patents sold for about $3 billion, and in 2014, 2,850 patents sold for $500 million. That is a rate difference of 61%. Fall in value compared to just 2 years before. The suggestion of that study was that this was primarily caused by invalidation rates coming out of the IPR process. Again, the reasons for such high invalidation rates: no presumption of validity, newly found prior art, mostly, that wasn't considered before by the examiner, although sometimes art that was considered by the examiner is used, a lower burden, and the low cost of IPRs compared to district court cases. It may cost a challenger anywhere between, say, $200,000 to $500,000 to make it all the way through an IPR trial, whereas defending excuse me, at the district court level, defending at the district court level may cost a challenger a couple $1 million, several $1 million maybe, to go all the way to trial to try to invalidate that patent or to prove that they don't infringe the patent claims. What can a patent owner affect with respect to the IPR process? Well, the presumption of validity, the lack of a presumption of validity is by statute. So a patent owner cannot affect that. A patent owner cannot affect the lower burden or the lower cost of the IPR. The only aspect of IPRs that a patent owner can affect, in my opinion, seems to be newly found prior art. That is, finding prior art before your opponent or your potential opponent finds prior art. So one solution, in my opinion, seems to be a pre-drafting patentability search. And what I recommend to clients is that a meaningful patentability search should accompany every approved invention disclosure. What does approved mean? Now, usually an inventive entity, what I'm calling an inventive entity, is a company that creates patents, has inventions. They usually have their own criteria for what an approved patent disclosure or invention disclosure would look like. If the invention satisfies that criteria, then they move forward with a patent application. One thing to consider, if you're an inventive entity, is if the invention is important enough to justify the filing of a patent application, in my opinion, there does not seem to be any sound reason for not pursuing a meaningful patentability search. However, it appears that that's not the case, and has not been the case for many years. Most of the time, inventive entities do not go forward with a pre-filing patentability search. And what are the reasons for that? Well, there are a number. Not enough funds in the budget. That's one reason. Oftentimes I hear an inventive entity will tell me, well, my inventor knows the art better than anyone else. Similarly, they may say, well, the drafting attorney knows the art better than anyone else. And finally, I hear a lot of IP practitioners say, well, we're going to rely on the examiner's search efforts. Now, do any of those reasons make sense? Well, let's take a look at the reason that there's not enough funds in the budget. If we look at the total cost for an issued patent, That may be around $80,000. You attribute $20,000 or $30,000 to get the patent allowed. That covers drafting, filing, responding to office actions. There could be another $10,000 or $15,000 in maintenance fees. And this last item, the $50,000, time and effort related to enforcement. After a patent issues, it usually just sits there in the portfolio. But oftentimes, issues will come up where corporate management will say, I want to know if we've got one or more patents that help us with respect to a potential competitor. So there's time and effort related to reviewing the portfolio, talking to outside litigation or enforcement counsel, and potentially filing a district court case. So all in all, with respect to an issued patent that you may want to enforce, you're looking at the start, $80,000 plus. What does a patentability search cost? Depending on the complexity, anywhere between, say, $1,000 to $5,000, and what that gets you is 20 to 40 hours of expert searcher's time. Now, if that prior art search comes back and you decide to go ahead and file the patent, well, that's a small additional amount to confirm or to strengthen the validity should you want to enforce that patent at a later date. On the other hand, if you decide based on the results of the prior art search not to draft the application, not to file the application, it's a small expense to make that decision. Either way, you've either strengthened the validity of the issued patent once it does get issued, or you spend a little bit of money to decide not to spend a lot more money in drafting that patent, paying maintenance fees, and reviewing that patent to determine whether you want to try to enforce it at a later date. Let's look at the reasoning where the inventor or the attorney knows the art better than anyone else. In my opinion, the statistics coming out of the IPR trial process doesn't support that. A meaningful search requires between 20 and 40 hours, again, depending on the complexity. I always ask my corporate clients, do you think your inventor or the drafting attorney is going to spend a similar amount of time searching for great prior art? Typically, the answer is no. Attorneys and inventors do not have that kind of time to do that kind of searching. What about relying on an examiner's search efforts? Again, I think a lot of times for a lot of the issued patents that did go through the IPR process, that those statistics don't support that rationale. Again, a meaningful search requires about 20 or 40 hours. In a recent article I saw from 2015, an examiner stated that he spent less than 10 hours drafting the first office action, and that included reviewing the application and searching for prior art. So maybe that search took 3 or 4 hours, who knows, but it's a lot less than 20 or 40 hours that you would get from doing a meaningful patentability search. So how do you strengthen validity? Let's first talk about what a patent is. A patent provides a negative right that is not self-enforceable. And that right is the right to prevent others from practicing the claimed invention. Enforcement, which is a combination of validity and infringement, requires a significant investment of time and money. So it seems to me that a meaningful prior art search is really the only way to strengthen validity. Now, how do the rules of ethics come into play here? Well, under the American Bar Association and the PTO's rules of professional conduct, a client makes all decisions concerning the objectives of representation. And the attorney shall consult with the client as to the means by which those objectives are to be pursued. So on whether or not to conduct a patentability search clearly falls within this ethical rule.
So, Eric, this is Deepak. I think this is a very interesting information, because if I share out our experience, there has been 50% rise in the type of requests that we are receiving for patentability search, and not just for the clients with whom we were working already, but with respect to the new clients also. So this means that a lot of people have realized this, and they are educating their client more by looking at what is happening these days with respect to IPR.
Well, that's what I like to hear, because I think this issue is so important that every client should be discussing it with their outside counsel or their corporate IP counsel. And let's pause here real quickly. I want to give the results from the first poll. 71% said yes, they think that most U.S. patents are valid. 29% said no. So let's go back to the ethical rules. Another set of rules, PTO Model Rule of Professional Conduct, Section 11.1045B, and it's a very similar to an American Bar Association rule, requires that the practitioner explain a matter to the extent reasonably necessary to permit the client to make an informed decision regarding the representation. So it is up to the attorney to educate the client with respect to the decision on whether or not to file a meaningful patentability search, and with respect to IPR invalidation rates, why they're so high, and how they affect the client's current portfolio and any later filed cases. So again, educating the client to me means with respect to patent validity, it requires a discussion on how and why a substantial majority of patent claims are rejected under prior art when brought before the PTO under the IPR process. So what does that discussion look like? I'm just going to provide a brief outline of what it might look like if the IP counsel is going to discuss this issue with their client. First, that the IPR process started in 2012. And over 4 years, we now have enough statistics to be pretty confident to tell clients that about 70% of all IPR trials result in invalidating all of the challenge claims. That's pretty concerning in my opinion. In addition, and this is going back to the quote from Rob Stern and Gene Quinn, it is quite possible that a substantial majority of the allowed patents are invalid in view of art if they were challenged in an IPR proceeding, given the lower burden and the lower thresholds to invalidating claims. So what does that tell you? It tells you that a patent that gets issued without the benefit of a meaningful patentability search may be of little value when it is enforced, say, 5 or 10 years down the road. So the takeaway is, both to IP attorneys and to clients, conduct a meaningful patentability search prior to making a decision on whether or not to draft and file a patent application. It's the client's decision under the rules of ethics. So let the client make that informed decision. Help the client make the informed decision by educating the client on what's going on and possible solutions. Okay, let's turn to poll number 2. Poll number 2, do you feel it's important for inventive entities to speak with their IP counsel about high IPR invalidity rates and prior art searching as a potential solution? That's our poll number 2. We do have some time for questions and answers. I'm going to take a look and see if there are any questions. And so far, we don't have any questions. If you do, if you're attending and you have a question, please feel free to submit a question. I'll try to do my best to answer it in the time we have left. In the meantime, I'll give you the results of poll number 2. So far, 100% have said yes. They do think it's important for IP counsel to have this discussion with their clients on high IPR invalidation rates and potential solutions, including, in my opinion, the main solution, which is doing a meaningful patentability search.
Eric, I have one question that I wanted to ask you, that why this question is coming up right now when I say that about the ethics, or about the 70% of the patents which are coming up are getting invalidated during the IPR. Do you think that this stats would have been the same if we look back 20 years or 25 years back when you started your career? Do you think it would have been the same? If not, why do you think it would have been different at that time?
Well, of course, 20 years ago, we didn't have this IPR process. So, no, I don't think the stats would have been the same. Now, 2 years ago, the stats were very similar. There had been 2 years from 2012 to 2014 worth of statistics to look at. And even then, the invalidation rates were very high, around the same amount, maybe a little bit higher. They've gone down a tiny bit in the past 2 years, but still very high compared to invalidation rates coming out of district courts. I think the reason why this is such an important topic now, and maybe a topic that is being discussed more and more with clients, is the fact that we now have 4 years of statistics, and this gives us a lot of support in talking to clients about the issues raised by high invalidation rates. In my opinion, in the past, most inventive entities did not do patentability searches, although in my practice 20 years ago, I tended to recommend doing a patentability search in all cases. I think that's going to change. I think it's going to change because of these kinds of statistics. When you have such high invalidation rates. Go ahead.
So do you think that the history is going to repeat? That means, what used to happen 20 years back, where attorneys used to suggest such kind of searches to their clients, will now start doing again, because that's how the statistics are coming up. So
well, again,
this is like saying history repeats itself after some time.
I hope so, because I really think it's in an inventive entity's self-interest to do a meaningful patentability search. As I'd mentioned before in one of the slides, you get benefits out of doing it either way. If you decide to file based upon the results of the prior art search, well, that patent's going to be stronger, much stronger validity-wise than if you did not do that search. On the other hand, if that prior art search comes back and you've got some questions as to whether or not your invention is patentable in view of those results, and you decide not to file, well, you made a good decision. You've saved yourself a lot of money by doing that prior art search. So either way, it's beneficial. And especially if you look at the cost in obtaining a patent and the cost of enforcing that patent over a long period of time, it's a minimal cost, and it gives you good, solid information.
So I have also heard, a lot of corporations not doing this because they don't want to see, a lot of prior art which can cause trouble with respect to, for example, known prior art, or with respect to litigations where it can be proved electronically that they were aware of few patents and intentionally they have not licensed it. So how do you think this can be challenged? Because this is a very big factor for the IP councils and companies.
Yeah, that's a tough decision to make, and I understand it. My feeling is that I would rather have the client have all the information necessary to move forward, either with filing patents or just proceeding with their business. I think it's important for a client to know whether or not their product or a potential product might be infringing. There are ways to avoid that. You can do a prior art search just on publications. Avoid looking for patents. See if there are white papers or standards or other kinds of publications that might be relevant or material to that invention disclosure. And of course, since they're not patents, since they're not patents, they're not going to have an impact on infringement or treble damages. And that is a way for a client to get an understanding of the landscape. But again, I think it's important to know as much as you can. But it is an issue, and it's an issue I understand.
That's a great idea, Eric, that looking at the publications, or I've seen few clients trying to not look at the report and trying to understand what kind of patents have been filed, maybe over the conference call, so that they can understand that what exists in the prior art. And there's also a very interesting observation that I would like to share with you and would like to know your views. In the last 5 to 7 years, I would say, I have seen two types of things coming up our way. So one is where people are less interested in going for prior art. And one of the reasons was that, what if there is a prior art exists and the client does not go ahead with a patent? That is a huge loss of business. And I have seen there is a other type of request coming in where, apart from the standard prior art or results, that means patentability results, the clients are also asking that if you find an exact invention in the prior art, why don't you suggest the different embodiments or the different areas where the invention could be tweaked, or a more patents can be filed or more continuations can be filed? Do you think that could be a great idea with respect to how attorneys and IP counsels can leverage the patentability searches?
Yeah, I mean, to answer the second part of your question on alternative embodiments, that's a really good point, because many times an invention disclosure comes out and the inventor is focusing on one embodiment, that's the one thing he or she has in his or her mind, and the drafting attorney will only look at that embodiment. And if you did find prior art on that embodiment, that's a problem. But oftentimes specifications, invention disclosures, may have several embodiments, and one or more of those may not infringe prior art that you found, or may be patentable in view of the prior art you found. So it's a good idea to look at that issue, whether or not there are alternative embodiments that could be helpful to the inventive entity. And I know we do that often. With respect to losing business, that is probably something that some attorneys think about. But I think more often than not, they want to do what's best for their client, and often clients have more invention disclosures that they can bring up and present to their IP counsel for potential drafting. So, I don't see loss of business as a real issue.
Understood. That means if you look at the long term, maybe you will have more ideas to increase the business with respect to additional patents that can be filed or additional continuations that can be filed, as compared to how many patents or applications could not take to the level of patent because of, an exact prior art was existing. So yeah, that completely makes sense, I would say. So I was, there's a very interesting, I would say, experience which happened with me personally last week, and I was in Qatar, where I was meeting a university over there, and we were doing some prior art searches for them. And in that discussion, when we were talking about the prior art or specifically patentability search, in that discussion, when we talked about the patents which were not exactly similar but were nearby, that discussion led to actually 3 more patents that came out of the results, and the attorney in the end ended up filing 3 patents rather than the 1 patent. So it was exactly, I think, what you mentioned, how it can be taken forward to the next level as compared to moving with the traditional thought process of what is the definition of patentability search.
Right, and inventive entities can include this kind of process in their internal process. Talking about the invention disclosure, alternative embodiments with respect to prior art results, and really focus on getting the best inventions possible patented. So it's really something that can be an additional aspect of the invention.
Understood. I think that completely makes sense. So I think that was from my side the question that actually I wanted to ask you at the end of this session. So I have just broadcasted to everybody the other questions that they may be having with respect to this topic. A few of them which I have asked. I think there could be more that the people might be having, and if they don't have, I think we can then end this session, which was, I think, good with respect to the new things that can be identified during doing a normal patentability search or a conversation with a client.
Right. Yeah.
So
I don't see any
open
further
to everybody,
questions.
I think now.
Okay. Yeah, I was going to say I don't see any other questions coming up on my chat menu.
Okay, so I think we are good then. So if we have no more questions, we have already answered the question that we previously had.
Oh, hold on.
We can call an end.
There's one.
And thanks everybody.
Yeah, just one briefly. There's one question. Can we email questions? And the answer is yes. Yeah, please feel free to email questions, and I'll try to get to them as time permits. Oh, here's one other question.
And there's one more question, Eric, that has come in, if you can take a look at it.
Okay, let's see. Let me see if I can pull these up. Okay, hold on one second. Okay, here's one question. Does it make sense to order a patentability search for in-process applications? The decision of abandoning may serve a lot of future, and I can't read the rest, but yes, you have an in-process application. There are opportunities to submit another information disclosure statement during the process. So I think it does make sense to order a patentability search for in-process applications, and you should discuss that with your outside counsel. See if there's still time available to do that. Okay, let's see. I think that was it. Will the slides be available?
From James. Yeah.
Okay, let's see if I can find it. Maybe you can give it to me, Deepak, because I can't seem to find it on my chat.
Sure. So So James is asking us that how do the cost of searches compare with the cost of attorney review and analysis of the same? Because I think there are 2 different parts, where one is search involved and the other is how attorney analyze them and provide his inputs to the end client.
Yeah, I mean, a meaningful patentability search will not only provide just the basic results, the patents or publications that are relevant to the invention, but also a report that spells out the most relevant patents or publications, and where within those patents or publications the substantive aspect of that reference can be found. That really helps the reviewing attorney to focus in on the important aspects of the reference, so it doesn't take them quite as long to review. But it will. I would, give a drafting attorney, a couple hours to review the prior art. Most attorneys, can cost anywhere from $300 an hour to $500 an hour prosecution-wise. But also, a lot of the work is done on fixed fee work, a fixed fee. So oftentimes this review is wrapped into that fixed fee. But it is worthwhile for the attorney to review the results, and I would recommend that the attorney always review all of the results, because they might see something that the searcher didn't see. They might see one of the references as more relevant than another.
So if we have to talk about a percentage, Eric, so what percentage of, how would you divide the percentage in terms of cost rather than the hourly pricing? Because, some people may really want to see it from the percentage perspective.
Percentage, like a simple search for a simple invention might cost $1,000. It might take an hour for the attorney to review. Say that's $400, so that's 40%. So you've added another 40% to the cost of the entire search process, so $1,400 total. That's still a small amount compared to the total cost of obtaining that patent and enforcing that patent and maintaining that patent.
Okay, so that would be like a 60-40 ratio that may come up, you mean, from the search cost.
Right. It doesn't take that long to review the results, especially when the attorney understands the invention well.
Okay, great then. So I think there are a few people who are asking about, if they would get the slides that we have and, the recording. So here's the answer for everybody who is asking this question. The recording and the slides will be shared with all the attendees after this webinar. So it would be available for you to review it. And if you have any questions, you can also send it by email, as Eric shared earlier. So I think Eric, we can thank everybody for joining in. It was good, and hope to meet everybody again in the next webinar when we have it in the next 2 months.
Yeah, we'll take up another topic in a couple months.
Sure. So thank you everybody for joining in, and we will be sending you the recording on the email. Thank you, everyone. Bye-bye.
Yeah, thanks everyone. Bye-bye.